So when you start learning about law, one of the things you realize is that if you're studying vehemently, adamantly, you will soon come to realize that your private record trumps any public record, okay? And the reason for it is you can testify with firsthand knowledge to your intent, okay? So your private record trumps any public record out there if the scope and the subject matter is pertaining directly to you, okay? Because you're the only one that can testify with firsthand knowledge. This is a very important fact to understand. The lawyers in a courtroom will try to confuse the situation that somehow you're bound to something that you're not. However, your private record trumps their public record, and I'm going to prove that to you. Although I wasn't able to prove that to 12 jury members. And again, the jury didn't fail me. I failed the jury, okay? I have the means and the ability to be able to explain this very well. The problem is, in that particular setting, my first trial I've ever been in, I look forward to another one someday. Maybe I'll even be interested in trial de novo on the one that I was in, based upon the fraudulent evidence that was utilized. And the fact that no real party in interest made a general appearance before the court, granting the court jurisdiction in the first fucking instance. They never had jurisdiction, okay? So, anyway, Mr. Anonymous helped me put this together, okay? He's a very learned man, and it took a shit ton of research and to go through it and make sure that I understood it. And my failure was not being able to explain it well enough in the court. Instead, I opted to read it instead of hand it to the jury and say, look, follow along with me. We're going to go through this together. I'm going to explain this shit to you, okay? So because I failed the jury, I won't fail you. I'm going to show you exactly why you don't have to have your automobile registered, why exactly you don't have to have it insured or any of that stuff, although I think insurance is a really good idea. I really do. There are a number of ways you can do it. You can bond it yourself. Remember, your autograph, your signature is the money, and you can create your own bond and lodge it onto the record, just like these people do too, with the court system. All right, this is a Memorial of Consumer Goods Primary Use 2004 Yamaha YZF-R R6, and I still ride the son of a bitch. I'm going to leave the VIN number out. And I still have constructive possession of it. All right, I'm the owner. Undisputed facts. Let the record show the primary use of the 2004 Yamaha YZF-R 6 is the use for consumer goods. All right, I'm creating my record. Okay, this is my testimony. This is what this toy, this motorcycle, is being used for. Okay, consumer goods means that that are used or bought for use primarily for personal, family, or household purposes as defined within the Uniform Commercial Code, Article 9, 102.23. I'm just showing them in their realm that it matches the Constitution, not only for the state, but also the United States of America, all right? I have the right to my property, and I don't have to give it up for public use or public consumption or anything else without being compensated for it, right? And I'm telling them what my use for it is. It's not for commercial purposes, all right? It's for private household consumer goods, primarily used for household purposes. Explanatory statement. I must object and do not consent to conversion of my private property into a fungible event requiring payment. Done v. Blumstein 405 U.S. 330 92 S period CT 995 31 LED 2D 274 5 U.S. Digest Constitutional Law and 101.5. The right to travel is an unconditional personal right whose exercise may not be conditioned. All right? And you can just simply go look up that case site that I said to you, and you will find the same language, okay? So the important thing about teaching people or planting the seed is at least showing them where they can go look for it themselves, okay? UCC Article 9, Secure Transactions, Sale of Accounts, and Chattel Paper, Part 1, Short Title, Applicability and Definitions, previously listed under UCC subsection 9109, Classifications of Goods, Consumer Goods, Equipment, Farm Products, Inventory, 31258, yep, that's a typo. Gotta correct that. Current UCC, subsection 9102 definitions and index of definitions, 23 consumer goods means goods that are used or bought for the use primarily for personal, family, or household purposes. 33 covers equipment means goods other than inventory, farm product, or consumer goods. Nebraska Uniform Commercial Code 9102 679.1021 definition and index of definition 23 consumer goods means goods that are used or bought for use primarily for personal, family, or household purposes. Now, why would I just take the UCC subsection 9102 definition and then turn around and show the same that was adopted by Nebraska's Uniform Commercial Code 9102? The reason I'm doing that is to show them that these are in harmony with one another in the commercial spectrum. And remember, all their courts are private, ad hoc, for-profit corporations, ladies and gentlemen, with DUNS numbers and insurance, and they're negotiating securities, right? They're in the commercial realm dealing with fictional shit. To prove my point, okay, there are men and women out here that can file court cases without giving any fiat, no Federal Reserve notes. You want to know why that is? Because a corporation has an obligation to pay for justice. A man and a woman, justice shall be had freely. The courts are open to the American people 24 hours a day, 7 days a week to express their grievances and get remedy, ladies and gentlemen. However, a corporation is responsible for paying for it, okay? So that's why they're charging you, is because you don't have a corporate denial on record. Get your corporate denial on record and let them know who you are, okay? It's not well enough to just walk in there, flesh and blood, living spirit, inhaling and exhaling. That doesn't do any good for you. To sit there and bark up a tree and tell them, I'm a man, I'm a man, I'm a man, does no good for you. Put that paper on the fucking record, okay? Corporate denial. And when you do that, you'll notice they're not trying to charge you any fees. Relevant applicable stare decisis case sites relating directly to previous UCC 9109 under UCC subsection 9109, there is a real distinction between goods purchased for personal use and those purchased for business uses. I'll be damned. The two are mutually exclusive. Remember, dissimilar things should not be joined, and similar is not same, okay? These are very powerful maxims that need to be seated deep in your mind. The two are mutually exclusive. That which is not included is excluded, all right? And in UCC 9109, number 23, it talks about consumer goods being primarily used for personal purposes for the household, okay? It doesn't say and commercial uses. It says primary use is for personal household consumer goods, period. Okay, so it does not include commercial applications. It excludes it because it doesn't mention it, all right? And again, I'm the only one that can testify as to what that motorcycle is going to be utilized for, all right? I'm not on my cousin Vinny, and I'm not rolling around on a crotch cricket delivering pizzas for profit. And I'm damn sure not using it to haul construction materials. I'm using it to go from zero to balls to the wall to get an adrenaline rush and enjoy the ride, all right? And so it's primarily used for pleasure, leisure, good times. The two are mutually exclusive, and the principal use to which the property is put should be considered as determinative. James Talcott, Inc. versus GEE, 5 U.S. Rep. Served 1028 and 266 California Appellate Court 2D 384 and 72 California Report 168 and 1968 was the case. The classification of goods in UCC 9109 are mutually exclusive. McFadden versus Mercantile Safe Deposit and Trust Co. 8 UCC Rep Serv 766, 260 MD 701, 273 A period 2D 198. This case was had in 1971. Automobile purchased for the purpose of transporting buyer to and from his place of employment was consumer goods, as defined in UCC 9, subsection UCC 9-109. Mail Coat versus Volunteer Finance and Loan Corp. 3 UCC Rep Serv 1035, 415 S period W period 2D 347 Tennessee Appellate Court. Case was had in 1966. The provisions of UCC subsection 2316 of the Maryland UCC do not apply to sales of consumer goods, a term which includes automobiles, whether new or used, that are bought primarily for personal, family, or household uses. Maryland Independent Automobile Dealership Association Incorporated versus Administrator Motor Vehicle Admin 25 UCC Rep Serv 699 394 A2D 820 41 MD Appellate Court 7. This case was had in 1978. Federal case law confirms, see company bankruptcy case printout, in regards to Barnes versus United States District Court, D. Maine, September 15, 1972, bankruptcy number BK72-129ND and number EK72-13OND. UCC 9109, consumer goods, automobile for transportation to and from work, the use of a vehicle by its owner for purposes of traveling to and from his employment is a personal, as opposed to a business, use as the term in UCC subsection 910223 679.1021 W, and the vehicle will be classified as consumer goods rather than equipment. The phraseology of subsection UCC subsection 9-1092, defining equipment as goods used or bought for the use primarily in business, seems to contemplate a distinction between the use of collateral in business and the mere use of the collateral for some commercial, economic, or income producing purpose by one not engaged in business. The appropriate filing place turns upon the classification of the collateral as consumer goods or equipment. The Uniform Commercial Code classifies goods as consumer goods if they are used or bought for use primarily for personal, family, or household purposes. FN 11 MRSA, subsection 9109(1). It is the court's opinion that the use of the vehicle by its owner for purposes of traveling to and from his employment is a personal as opposed to a business use, as the term is used in UCC subsection 91091, the phraseology of UCC subsection 11092, defining equipment as goods used or bought for use primarily in business, seems to contemplate a distinction between the use of collateral in business and the mere use of the collateral for some commercial, economic, or income-producing purpose by one not engaged in business. Traveling to and from work in a personal use, not a business use. This ruling is consistent with the undisputed fact that the classification of goods is determined by its primary use, Barron's Law Dictionary, 3rd edition, 1991, and not by the type of goods, including but not limited to vehicles. Consumer goods are not required to be registered. A vehicle not used for commercial activity is a consumer goods. It is not a type of vehicle required to be registered, and use tax paid of which the tab is evidence of receipt of the tax. Bank of Boston versus Jones, 4 UCC Rep, Serv 1021, 236 A2D 484 UCC PP 9-10914. Thus, Self-driven vehicles are classified according to the use to which they are put rather than according to the means by which they are propelled. Ex parte Hoffert 148 NW 20. The Supreme Court in Arthur v. Morgan, 112 U.S. 495 5 S period CT period 241 28 L period ED 825, held that the carriages were properly classified as household effects, and we see no reason that automobiles should not be similarly disposed of. Hillhouse versus United States, 152F, 163, 164, Second Circuit, 1907. U.S. versus Bomber, CA, California, I believe that is what that stands for, 5, Tex, 8F period, 3D, 226, 235, 19A, Words and Phrases, Permanent Edition, West Pocket, Part 94. The exemption provided for this Section 1 of the Motor Vehicle Transportation License Act of 1925 states 1925, page 833, in favor of those who solely transport their own property or employees, or both, and of those who transport no persons or property for hire or compensation by motor vehicle have been determined in the Bacon Service Corporation case to be lawful exemptions. In regards to Schmolik, 1926, 199, California, 4246. The right of a citizen to travel upon the public highway and to transport his property thereon in the ordinary course of life and business is a common right which he has under his right to enjoy life and liberty. It includes the right in so doing to use the ordinary and usual conveyance of the day, and under existing modes of travel include the right to drive a horse-drawn carriage or wagon thereon, or to operate an automobile thereon for the usual and ordinary purposes of life and business. It is not a mere privilege like the privilege of moving a house in the street, operating a business stand in the street, or transporting persons or property for hire along the street, which the city may permit or prohibit at will. Thompson versus Smith, 154 S period E period 579. In view of this rule, a statutory provision that the supervising official may exempt such persons when the transportation is not a commercial basis means that they must exempt them. State versus Johnson, 243, page 1073, 60, Corpus Juris Secundum, section 94, page 581. For the sites and legal opinions noted herein, forming my good faith and belief, I do act and order the record to show the primary use of the motorcycle be updated to show family household purposes, consumer goods, and provide an exempt tag, and I verify under the penalties of perjury under the laws of the United States of America that the foregoing is true and correct. By the way, I verify under the pains and penalties of perjury under the laws of the United States of America is found in Title 28, 1746, subsection 1. Go look at Title 28, 1746, and you'll understand why that's so important. Look at 1, and then look at 2. And you decide which class of quote-unquote person you would like to reflect on that record, all right? Do you want to be protected by the laws of the United States of America, the Constitution, the state constitutions, or do you want to fall underneath the federal enclaves under the laws of the United States and the United States alone? The choice is yours. It's right there in Title 28, 1746, subsection 1 or subsection 2. You decide. That power is up to you, okay? Of the laws of the United States of America, that the foregoing is true and correct, executed on the 11th day of June in the year 2021. All right, I won't bore you with the rest of this. Oh, we can't forget this. Oh, this is so important. Now, recently, an acquaintance of mine who's bringing suit against an officer, this officer took it upon himself to ring one of his friends in the next county over, the Thin Blue Line criminal gang thugs that they are. And he rang him up and he said, hey, this guy's sending me mail. You know, they got an IQ less than 70. They don't understand what's really going on. They have no fucking idea. When you bring suit, They really don't know what's going on. They think it's a joke. They think they're fucking protected. Ladies and gentlemen, the legislators and the lawyers have got it into their head that they're immune, okay? So when you start sending private communications to them, holding them accountable and getting them basically to show their intent by failure to correspond with you, you let them know, hey, my intent is to bring suit, unless you provide remedy or, whatever, however your communication is going to go, really. You don't want to threaten them because that constitutes extortion by way of mail, which is a violation of Title 18, 1341, 1342, extortion by way of wire and false fictitious names and all that shit. You don't want to really threaten them. What you want to do is let them know that they've caused you a harm, okay, that is in fact a trespass, and they're a wrongdoer, and that harm was caused by them extorting you on the side of the road, or theft of your property, or whatever the cause of action may be, right? You don't want to put a bunch of emotion in there. You don't want to try and educate them on the law. You just want to state the fucking simple facts. This is what's going to happen in the next 30 days. I'm giving you notice and opportunity to provide remedy now. If you don't wish to do that, that's fine. The second notice is going to be a little bit more escalated. Okay, very apparent that, this is just a courtesy. On such and such day at such and such time, you were a wrongdoer. You caused me harm by way of trespass. And at this point in time, is it your intent not to provide remedy? Now you can prove intent. They didn't respond. That was the trick about putting that word intent in there, because intent is so hard to prove. But if you put it in there, your failure to respond will exhibit your intent to continue to cause a trespass, to continue to cause me harm, and to continue to fail to provide remedy for the wrong that you did that caused me a harm, loss, or damage, right? Now, when that officer rang that other cop in another county and said, hey, go to this guy's house, I want you to knock on the door and tell him to stop his shit, okay? That's a criminal act. And it also constitutes conspiracy against this man's unalienable rights to get a remedy for a trespass that happened by this other agent. And because he's phoning people from another agency to go harass this man, harass him without a warrant, without a protection order or anything that's went through the court. Now you have these thin blue line criminal gang members, all right, taking justice, or what they purport or believe to be justice, into their own hands. That's an issue. That's time to stand up, make a record, make a report, swear on an affidavit to the facts and what happened. If you have camera footage, preserve that shit, all right? You're going to want to use it against them, because now they're conspiring against you under the color of authority. They're using their friends who have an oath of office, allegedly, and whether they do or don't doesn't make a difference, because remember, equity imputes an intention to fill a motherfucking obligation. All right. Second, you took that paycheck from the state, motherfucker, I got your ass. Their ignorance of the law excuses no one. No one. All right. Including myself. Everybody say, oh, you think you're above the law. Oh, no. I'm actually bound by a higher law. I am actually bound by the law. I am not bound or restricted by policies and fucking decisions made by a bunch of hypocritical pieces of shit. I'm actually bound by the fucking law, and they are too. You can be part of that corporation known as the United States all you fucking want. It's subsidiary corporations and subdivisions. That's all grand and fine. I don't give a fuck. But you still, working for that outfit and that hierarchy, are not impervious from the law. You're not immune from the law. Nobody is, all right? And it is very, very, very fucking clear in the Constitution. No man is above the law, because all men are fucking equal. And that little sentence right there means that nobody has 11th Amendment fucking qualified immunity. You might have it in your subdivision, your corporate crime policies, all that bullshit. But when it actually pertains to the law in reality, nobody's above it. All right. So this is what happens. And this is kind of lengthy, but I'm going to give it all to you because you need to have this in your arsenal. Okay. And this was developed because of the RICO Act. All right. The mob bosses were whacking people left and fucking right. Aunties, cousins, uncles, brothers, sisters, mothers, fathers, you named it. If they thought you were going to testify against them, they'd just kill your ass. You'd be swimming with the fishes. All right. So this is when this part got created. Okay. And it was part of the RICO. Notice, the certifying affiant is an independent contractor and not a party to the claim. In fact, the certifying affiant is a federal witness pursuant to tampering with a witness, victim, or an informant. All right, so this is the caveat for my process servers. This is the caveat I use for my notaries, just in case these people who are uppity in society get a little fucking nervous and their panties get in a bunch when they get a notice from me and they decide to reach out to somebody that is assisting me in process of service. All right, everybody gets this caveat, because if they step out of line, I got their ass. They can't proclaim that they were ignorant of the fact, because I served their ass with it. All right. Tampering with a witness, victim, or an informant. See Title 18, Part 1, Chapter 73, Section 1512B. Whoever knowingly uses intimidation or physical force, threatens or corruptly persuades another person, or attempts to do so, or engages in misleading conduct towards another person with intent to 1. Influence, delay, or prevent the testimony of any person in an official proceeding. 1. 2. Cause or induce any person to A. Withhold testimony or withhold a record, document, or other object from an official proceeding. B. Alter, destroy, mutilate, or conceal an object with the intent to impair the object's integrity or availability for use in an official proceeding. Now you see why I tell you to run down there to the police station and immediately file an electronic preservation, electronic ESP, electronic surveillance preservation request. Okay. Because it's all part of this Title 18, Part 1, Chapter 73, Section 1512. All right. That's why you run down and get an immediate ESP preservation request, electronic surveillance preservation request, because in the 21st century, fucking everything's on camera. All right. I wouldn't be surprised if when you use the morning loo in the morning, that your turd going down a toilet doesn't have a camera. Okay. There's probably a picture of Mr. Hanky going in the morning. Now, B, alter, destroy, mutilate, or conceal an object with the intent to impair the object's integrity or availability for use in an official proceeding. Okay. Electronic surveillance preservation request. Write it down. Every time you have an interaction and you look around and you see cameras, find out who owns those cameras, find out who's in control of those cameras, and immediately serve them with an electronic surveillance preservation request. If you can show the court that you did that and these half-wits destroy the fucking footage, they can be held liable. C, evade legal process summoning that person to appear as a witness, or 2, produce a record, document, or other object in an official proceeding, or D, be absent from an official proceeding to which such person has been summoned by legal process, or 3, hinder, delay, or prevent the communications to a law enforcement officer or a judge of the United States of information relating to the commission or possible commission of a federal offense or a violation of conditions of probation, parole, or release pending judicial proceedings, shall be fined under this title or imprisoned not more than 10 years. What is that called or constitute as? Misprison of a felony. If you know a crime's afoot and you don't fucking report it, you just became an accessory after the fact. You have a duty to report crimes when you see them. If you have the ability to stop them without getting hurt, you have the right to go ahead and execute a citizen's arrest, or both. The certifying notary also performs the function of a quasi-postal inspector under the Homeland Security Act by being compelled to report any violations of the U.S. postal regulations as an officer of the executive department. Now, your notary might not know this shit, but if you have the knowledge and you just maybe slip it in their ear, hey, that's a postal violation. You should probably do your civic duty and fulfill your obligation to your oath that you took, which you're independently bonded for, and go ahead and report that up the chain of command. Okay? And you can do it anonymously. All right. Notary public postal regulations as an officer or the executive department. We have no evidence how intimidating a notary public under color of law is not a violation titled. Deprivation of rights under the color of law, see Title 18 U.S. Code subsection 242, which appears to primarily govern police misconduct investigations, making it a crime for any person acting under the color of law or color of authority to willfully deprive any individual residing in the United States those rights protected by the Constitution. Sounds like a 1983 action, doesn't it? And U.S. laws. Other possibly related federal statutes, see Title 18 U.S. Code subsection 241, conspiracy against rights. See Title 18 U.S. Code section 1512, obstruction of justice. And see Title 18 U.S. Code section 1001, false statements. Or, let's see, it's false statements, but if you read it more clearly, it pertains to syntax grammar, okay? While appearing to generally restrict color of law investigations to officials' actions taken by police officers, federal agents, sheriffs, deputies, correctional officers, and other public safety officials. Off-duty officers who who assert their official status also may face prosecution. That means if one of the thin blue line criminal thug gang members calls his buddy because he doesn't like the fact that his ass is getting handed to him through the postal service, right, by private administrative process, and he calls somebody who's off duty who comes over in plain clothes to threaten you to say, hey, you better stop getting a hold of Tom. Well, buddy, your ass isn't immune either, all right? Okay. And deputies, correctional officers, and other public safety officials, off-duty officers who assert their official status also may face prosecution. The action of security guards, private citizens, judges, defense attorneys, and prosecutors who willfully participate with federal, state, and local enforcement officials in the commission of a color of law violation may fall within this purview of federal statute. Postal inspectors are federal law enforcement officers with investigative jurisdiction in all criminal matters involving the integrity of the mail and the security of the U.S. Postal Service. U.S. Postal Inspection Service, Security Investigation Service Center, 225 North Humphreys Boulevard, 4th floor, Memphis, Tennessee, 38161-0001. Thank you for joining me. I love you all, and I hope this helps you out again. Remember, if your friends are witnesses to crimes under the color of authority, the color of law, simulating a legal process, remember to read up on Title 18, Part 1, Chapter 37, Section 1512. Also become fluent with Title 18 U.S. Code Section 242, Title 18 241, Title 18 1512, Title 18 1001. You might also want to become fluent with Title 18, 1341, 1342. There are a number of others, obviously, but these are some very good key points. And again, this all stemmed from the RICO Act. And when the mob was whacking people left and right, they had to do something to protect their witnesses. And this is what they did, all right? And this gave the federal marshals, Secret Service, an abundance of power to protect these people. The Witness Protection Program and everything else manifested after this as well. But again, this applies to everybody. Nobody's fucking immune from it. If you're filing a claim against somebody and you have corrupt agents and agency, the mayor, the governor, the senator, the congressman, sending you threatening letters, impeding your process, you can have them hemmed up on Title 18, Part 1, Chapter 73, Section 1512. All right? Love you guys. Talk to you soon.